hard for me to hear, so I'll try not to shuffle my papers as much. Can everybody else hear okay?
Yes, sir.
Okay. And I would just ask counsel, make sure that you are, Mr. Zansberg, one thing I learned doing trial in the pandemic is that please face your computer, okay? Because if you move around too much, the microphones on computers are apparently directional, and so it messes up and we might not catch all of the record if you're shifting too much. And then likewise, counsel for our appellee, just please make sure you're speaking into that microphone, okay? Okay.
Yes, sir.
All right. I think that's everything. Are we ready to go? Yes?
Yes.
Okay, great. Mr. Zansberg, if you are ready, if you would please enter your appearance.
Yes, and thank you for accommodating me by appearing virtually. This is Stephen Zansberg, bar number 26634, on behalf of the plaintiffs and appellants, Robert C. Marshall, Laura Thomas, and Julie Gooden.
Thank you. In just a moment, I don't think I said the case number. The case number is 25CA940. All right, so Mr. Zansberg, and again, if you just walked in, please make sure that your devices are all the way off, okay? Mr. Zansberg, whenever you're ready.
Thank you, and may it please the court. The only question before this court today is, did the district court err when it found that absolutely none of the topics listed on the agendas for discussion or topics that were actually discussed at the closed-door meetings challenging the complaint constituted public business of the board, as that term appears in the open meetings law? That conclusion, that legal conclusion reached by the district court, is the sole reason that it determined the open meetings law had not been violated, and therefore no preliminary injunction should issue, barring other similar closed-door discussions by the Board of County Commissioners. And notably, the BOCC, the board, does not argue here that the topics listed on the agendas, which is uncontroverted evidence below, and the formal process for initiating the Home Rule Initiative that was discussed the 3 elected official meetings, was not public business of that public body. They've thus conceded the point in their briefing, and they cannot now present new arguments today at oral argument for the first time to defend the district court's ruling. And it is truly remarkable that the defendant has completely abandoned any effort to defend the very findings and conclusions that it tendered, and which the district court adopted wholesale, rather than argue that the actual topics listed on those agendas for the 11 advanced planning meetings did not constitute public business. The defendant instead now asks this court to find the case is moot, or it argues the plaintiffs failed to present evidence establishing who was expected to attend and which topics were expected to be discussed at these meetings. Those facts are not disputed. They are in the record. Exhibit 12, admitted into evidence, shows exactly which topics were listed on the 11 meetings described as advanced planning meetings. And the evidence was also undisputed that Exhibit 4, the PowerPoint presentation by the county commissioners showing what needed to be done to begin the Home Rule Initiative process, was discussed by the county attorney with the 3 members of the Board of County Commissioners present at the 3 elected official meetings. There's no evidence to the contrary. So the only question is whether or not those topics constitute the public business of the county commissioners. And under this court's precedence and that of the Colorado Supreme Court, there could be no serious contention that those are not topics within the public business as defined in the precedents interpreting the open meetings law of the Board of County Commissioners, including discussing a resolution, 2 resolutions in Exhibit 4, pages 7 and 8, that discuss the very resolutions the Board of County Commissioners voted to adopt on March 25th of last year, that they are statutorily empowered to adopt. It is within their statutory authority to do that which they did on March 25th.
Mr. Zansberg, let me interrupt you and ask you, how does what you're describing to us compare or contrast with the district court's findings that at those advanced planning meetings and executive sessions that there was only day-to-day scheduling matters and other similar items that were discussed?
Well, first, Your Honor, thank you for the question, but the court, the defendant here, the appellee, has made no argument in its answer brief suggesting that seeking to defend that portion of the district court's order that it tendered. And as we pointed out in our briefing, the word supervision does not even appear in the transcript of the entire preliminary judgment hearing because that argument was not made below. There was no argument presented below for the court to enter a finding that these meetings constituted the day-to-day supervision of county employees when they are, in fact, elected officials, not employees. And the advanced planning meetings, I'm sorry, they were attended by employees, but they were not day-to-day. They were more likely on a weekly basis, and the types of topics that were actually listed for discussion at those meetings were anything but the day-to-day supervision of county employees. And as I said, the county has not even, the Board of County Commissioners has not even made any argument in its answer brief that that was an appropriate finding. Instead, what we do know was listed in the agenda topics, again in Exhibit 12, among the topics listed for discussion by an attendance of a quorum of the Board of County Commissioners was whom to appoint to various boards and commissions. That is not day-to-day supervision, and it's clearly within the public business of the board. In fact, they take formal action when they do vote to appoint members.
I'm sorry, Mr. Zansberg, I'm going to just ask you a question. So, I mean, obviously, the parties are on opposite ends of the spectrum as to what we should be looking at and how we should even be reviewing this. It's my understanding is that your argument is that our review is de novo because the conclusions about whether there was public business, a subject that was subject to the open meetings law, is a legal conclusion. Am I understanding your position correctly?
That's correct. The only facts that were subject to dispute, but there is no dispute under the testimony and admitted exhibits, is the questions the county claims are disputed, who was expected to attend or did attend these meetings, and what topics were discussed, what was the actual substance or subject matter of what was discussed. There's no dispute as to either of those issues. In fact, the order they tendered conceded that it was undisputed that a quorum was expected to attend all 11 advanced planning meetings. The evidence was also undisputed that all 3 county commissioners were in attendance at the 3 elected officials meetings at which they purported to convene an executive session, which they wouldn't have needed to do if there wasn't a quorum present. So both the who attended and what topics were subject to discussion or listed for discussion is undisputed. And the only conclusion reached by the court below was that that didn't satisfy what is the public business of that public body. And that's a legal conclusion subject to de novo review. I will reserve the remainder of my time unless the panel has other questions for me at this time.
Doesn't look like it. All right, so we've got about...
Then I will be glad to reserve the remainder of my time.
Counsel, whenever you're ready.
May it please the court, Andrew Steers, registration number 40139, honored to represent the Board of County Commissioners of Douglas County. Your Honors, This case is less a case about the law and more a case about the record underneath. Plaintiffs asked the court for a preliminary injunction. In asking for a preliminary injunction, they got a hearing, and at that hearing, they had to present evidence to the court that would satisfy the 5 Rathke factors. What the court below found is that upon the evidence that they presented, they did not present what the Supreme Court called a meaningful connection between the meetings that happened and the public policymaking basis. In fact, our argument is, and I don't believe it's an argument, I believe the record is quite clear on this, that they didn't prove how many advanced planning meetings happened. What we have are 11 admitted exhibits which show that there were 11 agendas. But we also have the county attorney testifying that these were often canceled meetings, that they did not always occur. That was never clarified. So essentially, the argument for plaintiffs in terms of the advanced planning meetings and the agendas boils down to the existence of these agendas must presume that the meetings happen. Even the district court, in its order, found that a quorum of county commissioners was expected to attend. But it also found that plaintiffs never proved that they actually did, or that these meetings actually occurred.
Mr. Sears, can we talk about the March meetings, though?
Yes.
I think it was March 3rd, 7th, and 10th. It was the
Yes.
beginning of March. But
there were 3
whatever
March
the March
meetings.
meetings were that occurred before the March 25th, when the resolutions were adopted.
Yes, sure.
Talk about those, because even assuming we agree with you that there wasn't sufficient evidence to prove that the advanced planning meetings occur, there's not really a dispute that those 3 meetings occurred, correct?
Correct.
Okay. So talk to us about why you think that the plaintiff, which court we're in, that the plaintiff hasn't made that link.
Your Honor, I believe those 3 meetings, I think, are a little bit different in terms of those 3 meetings. There absolutely was a quorum of the Board of County Commissioners. There were also all the other elected officials. Those 3 meetings were initially so that, well, the first meeting, going by the testimony of the county attorney, was so that he could provide legal advice. That's why they went into executive session, so that he could provide legal advice to all those elected officials, all of whom he represents, and the Board of County Commissioners regarding the potential legal impacts, regarding, first of all, the process of getting a home rule resolution and the potential legal impacts down the road of what, if the voters approved that would look like. So he did discuss that, but you also have the testimony of Toby Damish, and we acknowledge that presentation was given, and he said he answered legal questions about the process. Toby Damish, the assessor who was at 2 of those 3 meetings, testified that the resolutions themselves were never discussed, and George Teal testified that, to his recollection, the resolutions were never discussed. So I believe...
Mr. Steers,
yeah, sure.
if I could interrupt you, my understanding is, from reading the transcript of the preliminary injunction hearing, is that there was at no time a statement that, contrary to what you just said, that there was going to be these executive meetings in executive session. Is there something in the record that shows that statement, such a statement, was ever made?
I believe my recollection of the transcripts is that Assessor Damish testified he didn't recall a statement being made. Attorney Garcia testified that they did have the process. I want to be very clear. We're not saying it was the cleanest process in the world. It was not the cleanest process in the world. There was no recording made of that invocation. However, I think at best the record is mixed. The intention clearly from the 3 people who attended that, Attorney Garcia, Commissioner Teal, and Assessor Damish, both of whom 3 testified, was their understanding was this was executive session and they were receiving legal advice.
So my recollection also is that the transcript said that those sessions were to provide legal advice. Is that your understanding?
Yes, sure.
So I believe that the open meetings law says that if a public body is going into executive session, that there have to be certain statements made, including the reason for going into executive session, and to provide as specifically as possible what the topic of or topics of that executive session are going to be. Is that consistent with your understanding?
That is consistent with my understanding, Your Honor.
So was that actually done, or are you saying the record is not clear about that?
My recollection is that Jeff Garcia, the county attorney, testified that to his memory that was done on all three occasions, but that no recording was made of it. I think he testified there was a back and forth with Mr. Zansberg, and I believe that Mr. Garcia that they disagreed on how it should be phrased. So I think that the record is unclear as to the exact phrasing that was used. And like I said, I'm not going to stand here and say that the record says there was a perfect process. It appears to have been somewhat imperfect, but I think the intention of the county and the county attorney was clear for that to be an executive session.
But it doesn't, doesn't the case law say the intention doesn't matter?
It does.
Okay. So, so what do we do with that, I guess, is my question, because I think saying it wasn't the cleanest record is somewhat generous. I think the statute is clear that it's supposed to be recorded, right?
Yep.
And it wasn't recorded. There's no dispute about that, correct?
No dispute.
Okay. And so I guess my question is, what do we do with that? Because it seems to me the county's argument is that even if that occurred, there still wasn't the link between the issue of public concern and an actual decision point such that we really needed to really be compliant with open meetings. Am I summarizing that? If I'm not, please tell me.
I think you're summarizing it correctly, Your Honor. Because what the testimony is that discussion was about the legal content. As I said, it was both about the process of how you get to a home rule charter and about the what the legal consequences. My understanding from the testimony is that the elected officials were concerned about what the consequences of a home rule charter would be for them, because, for instance, the law provides that you can take an elected position and make it an appointed position. So they were concerned about things like that. But I think that is a far cry from saying that they were only discussing the resolutions. In fact, when there's testimony that they did not at all discuss the resolutions, that they were providing legal advice and legal questions. The remedy, I believe, that the court would do is that the content of those executive sessions would then have to become public.
Except they can't because they weren't recorded, right?
They can't because they weren't recorded, but the PowerPoint itself has already been made public. The PowerPoint that was used has already been made public from those. That's the PowerPoint that was admitted as an exhibit because it was later used in the hour-long public Q&A that preceded the vote.
But there's a dispute about the length of and you're talking about March 25th. I just want to make sure
Yes.
you're talking about. Okay.
Yeah, sure.
Isn't there some conflicting evidence in the record about just how long that, opportunity for public comment was?
Well, I think what's important in the record got muddled on this is that there are two things that happen on March. There's a number of things that happen on every day, but there's two things in regards to this that happened on March 25th, which is there was a luncheon that was open to the public that was properly publicly noticed that discussed home rule, where the county attorney made a presentation. He testified that members of the public attended and asked him questions during that period, and then they proceeded into the vote. And there is some dispute over how long the vote took. I would point out, I don't think the record's very clear on this, but the resolutions themselves are just a couple of sentences. So they were read. The reading and the vote took about 90 seconds. There were members of the public there, as counsel for the plaintiff did point out very astutely, with the mistake that the county attorney made in saying there was no one there. There were a lot of people there on the video, but they chose to not take that opportunity to ask questions about the resolution. I don't know if that's because they'd had that opportunity before in the hour-long public meeting, but certainly that hour-long public meeting did occur, and that is discussed in the record, Your Honor.
It is my understanding, counsel, that the home rule issues went to a vote of the public and failed.
Yes, Your Honor.
How much or how little of this case does the failure of those two resolutions moot this case?
We believe it moots the case. I think it clearly moots it, and I believe plaintiffs have admitted that it is mooted as the home rule issue. My read of the hearing and my argument is that if you go back and look at the hearing, the final ask that plaintiffs make at the end of the hearing is for a limited injunction that simply prevents the election from taking place. I'm acknowledging that in their motion for a hearing and at the beginning of their hearing, they asked for a broader injunction. Counsel's pointed that out in his reply brief, and he's correct. However, at the end of the hearing, They narrowed their request for an injunction. And the fact that the election has occurred and was defeated, we believe moots the entire issue.
Now, I believe that counsel argues that it's not completely moot because there are problems with the process here. And the question is, should we be concerned that these problems with the process are going to continue? You just admitted to one of those problems. There was no record made, which is a considerable problem. So why shouldn't we be concerned about the process?
May I ask a clarifying question, Your Honor?
Yes.
In terms of, are you talking about specifically the elected official meetings? Are you talking about the advanced planning meetings? Are you talking about all of it together?
Both.
In terms of the advanced planning meetings, the process there, I think there's a clear factual issue with the record in terms of the advanced planning meetings. The testimony before you, and I'll summarize it obviously, but you have the record, is that these did not always happen, that we have 11 agendas. The discussions that happen on those, essentially, my argument with the advanced planning meetings is that what plaintiff is asking for on there is a new read of the law, namely a completely and purely topical analysis of what's on an agenda, and a presumption that if it's on an agenda, it was discussed, because there was no evidence on several of the topics on the agendas as to whether or not they were discussed. The evidence you do have is that the county attorney said he's present at all of these when they occur, and he prevents policymaking discussions from occurring. It was also said, I believe, by both him and Commissioner Teal, that the main purpose of these are scheduling issues and comms, and others communications that the county issues. Given that, that falls clearly within a purely administrative meeting and them talking about purely administrative matters. So in terms of that process, on this factual record, and I think the district court made a really great ruling here, because they said on the factual record before me, I can't make a finding that these violate the open meeting law. And that's the problem, is there was no developed factual record about what happens in the advanced planning meetings. In terms of the executive or the going into executive session, I think the county attorney discussed the issue that he was aware he made a mistake by not recording these. So in terms of that process, the court could clearly find there was a violation if the court wanted to. But I would argue that that session, since that is purely home rule, is mooted at this point.
Mr. Steers, my understanding of the open meetings law is that if there is going to be a meeting that comes under that law, that the agendas indicate what issues are going to be discussed, and then that triggers the requirements for public notice. Is that your understanding as well?
Yes and no. I think what the Supreme Court has held in Castillo County is that there has to be more than simply a topical analysis. We believe that the analysis the Supreme Court wants is both topical and functional. What actually happened in those meetings, and that there has to be some tie. Because if we were simply to rely on these agendas, for instance, counsel has urged, as an example, that the inclusion of immigration on the agenda, that is clearly a policy issue. We would argue that under IREA, where they talked about Intermountain, or the appellant in that issue, the board in that issue, commenting on legislation, like that, the board doesn't have any immigration purview. It can't make policy on immigration. So that's a per se not policy. When you look at what they were doing, and we have testimony on that, they were simply talking about whether or not to issue a statement in regards to President Trump. I think I'm answering your question, but I'm not quite sure, Judge. Did I?
I'm not sure that you did.
Okay. Tell me what I didn't answer.
If a public body is planning to have a meeting,
yes,
and the agenda raises issues of public policies, and let's say, for example, whether there should be a home rule charter approved, does that, just the fact that that's on the agenda, trigger the requirements of the open meetings law?
I don't believe so. I think that there has to be a deeper look, because the question could be, for instance, on home rule, are we talking about just holding a press conference? I don't think that's public policy, and I don't think any court has ever found it is. Are we talking about the substance of what that would mean? That's a different issue, and I think that would clearly trigger it.
Isn't that part of the problem, though, is that at least regardless of whether there's sufficient evidence to support whether the meetings were held, the agendas in some spots are kind of bare bones. Can we acknowledge that?
I would acknowledge that, but I think the majority, and Your Honor, may I continue?
Yes, please.
I would think the majority of agendas that I have seen for most public bodies are pretty bare bones. They simply list, topic, resolution, things like that. They don't go into a lot of detail.
Right, and again, just thinking through it, and counsel and panel, if I can finish my question, if you're okay with that. Part of my understanding of the open meetings law is part of it, though, requires, for example, if you're saying you're going into executive session, and so I'm looking at some of the exhibits that the county submitted for the work sessions, for example. It just says, elected officials, executive session, and doesn't give at least a little bit more information about what the executive session is about. My understanding is that open meetings law requires that, even though you're not required to divulge all of the things that you might talk about in executive session because they be confidential. Is that your understanding?
Yes, but not necessarily on the agendas. My read of the case law is that there does have to be, which is why it's ordered that they be recorded, is that there does have to be as full as possible, without disclosing the privileged material, discussion of the reason for going in, and then some recitation without disclosing privileged information, a discussion of what happened going out. Does that answer your question, Your Honor?
I believe it does.
Thank you.
And if the clerks would add a minute and 30 to Mr. Zansberg's time, please. Okay, go ahead, Mr. Zansberg.
Thank you, Your Honor. Mr. Steers argued that the plaintiffs didn't prove how many advanced planning meetings had actually occurred. There's no dispute whether or not all 11 occurred. There was testimony of several of the, first of all, the agendas were identified as agendas that were distributed in advance of meetings that were intended to occur, that were undisputedly to be attended by a quorum of the county commissioners. There's no dispute that those were the topics listed for discussion. There's no dispute that no notice of those meetings was ever distributed. And there's no dispute that no public attendance of the meetings that did occur was allowed. The combination of those undisputed facts is proof of the open meetings law being violated. The reason why notice is required in advance of a meeting is because we don't know which of the topics on the agenda are going to be discussed. We don't give notice after the meeting. We give notice prior to a meeting for any, and it's required to be given whenever a quorum is expected to be in attendance, which is undisputed, and public business is expected to be part of the discussion. Whether or not any decisions are made, even in working sessions, notice must be given. So the undisputed evidence is that the open meetings law was violated, and that the county commissioners has continued since then to continue to conduct these so-called advanced planning meetings to discuss public business of the board without providing any notice or without providing public attendance.
Mr. Zansberg, if I may interrupt again. So what is your view about whether the open meetings law applies to advanced planning meetings if an agenda is prepared but then no meeting is held?
Well, if no meeting is held, then there isn't a meeting that was not properly noticed. So there wouldn't be a violation for a meeting that did not actually occur. At the record at page 257, page 33 of the hearing transcript, Drew Campbell testified that the meeting, the advanced planning meeting did occur, that the county survey, something that the Board of County Commissioners has to do every year. It's within their statutory authority and therefore is the public business of that body that the discussion of the county survey did occur at that meeting. On page 260 of the record below, page 36 of the transcript, she also discussed changing the rules for public comment before county commissioner meetings, which this Board of County Commissioners changed in January of this year. That was the topic of discussion at the advanced planning meeting that did occur, as Ms. Campbell testified. On page 379, Commissioner Teal testified that at an advanced planning meeting, yes, the discussion of a resolution, a formal resolution to be adopted by this Board of County Commissioners approving or some form of immigration resolution. Mr. Teal referred to it as supporting the president's views on immigration, was discussed. There was absolute evidence that those topics were not only listed for discussion, but were actually discussed at advanced planning meetings. So even if all of 11 of them did not occur and we didn't go through and confirm the conduct of all 11 of them, we certainly did establish that certain topics of public business in the advanced planning meetings did occur without public notice and without public attendance. And that process was understood by the county attorney as being fully lawful, and he fully intended to have his clients continue to conduct those types of meetings as they have done to this day and are continuing to this day to violate the open meetings law and deprive the people of Douglas County of their statutory right for notice and public attendance. As to the elected official meetings, we did establish undisputedly that all three of those luncheon meetings did take place, that the entirety of Exhibit 4, the PowerPoint presentation, was presented by the county attorney, providing essentially the same legal advice to his clients that he had provided previously in a properly convened executive session to the county commissioners. And the whole reason they did these elected official luncheons and walked through that PowerPoint deck and the county attorney answered specific legal questions without properly convening the executive session, that was their admission in their tendered findings and conclusions that the court adopted, that there was not a properly convened executive session on March 3rd, 10th, or 17th. But the whole reason they purported to do that as an executive session was because there was a quorum of the county commissioners in attendance, and they were discussing county business, the very same business that they had previously discussed in an executive session. Therefore, those three meetings also were proven without any dispute to violate the open meetings law because they were public business, just as they were when they previously convened an executive session to discuss that exact same PowerPoint deck. And as for a reasonable connection between the topics discussed and later board action, yes, they discussed two resolutions that were adopted by formal vote of all three commissioners on March 25th of last year. The very two resolutions mentioned on pages 7 and 8 of Exhibit 4. That was the topic of discussion at those sessions, and that is a meaningful connection. And as this court held in Anzalone versus Town of Del Norte, 2024 Court of Appeals 18 at paragraph 42, so long as action taken by a public body is within its statutory authorities to act, it bears a significant enough relationship to their policy formation authority to satisfy the public business requirement of the open meetings law. And as for lastly, for the Rathke factors that Mr. Steers says the trial court did not make findings upon, that is because the order they tendered did not address any of those factors with respect to the second form of request to enjoin any further meetings that did not comply with the open meetings law at which public business was discussed. irrespective of any decision making, irrespective of the vote. And that was not abandoned or limited at the end of the hearing. In fact, our proposed findings and conclusions that we tendered addressed each one of the Rathke factors with respect to that second request for preliminary injunction. And for that reason, we asked the court to reverse and remand to the district court to enter the preliminary injunction that plaintiffs established they were entitled to receive.
All right. Thank you very much, counsel, for your arguments. They will certainly help us decide this issue, and we'll issue an opinion in due course. That should conclude our oral arguments for today. Thank you, everybody, and we'll be in recess.
Thank you, Your Honors.